Investigators are preparing for Thesis-Gate's online hearing in the UK courts. This will be a hearing for Michael Richardson's appeal after he lost in the tribunal court. Richardson plans on bringing every last piece of evidence he can muster to show that the University of London and the ICO are hiding Tsai's examiner names and viva date behind personal data principles, which violates the UK Freedom of Information Act. The school and ICO's goal is to shield Tsai Ing-wen from her academic dishonesty controversy. Richardson intends on overturning the tribunal court decision by proving that the ICO's ruling, saying he had no legitimate interest in knowing Tsai's examiner names and viva date, were false. Luckily, there are several precedences that he can base his argument off of. The Birkbeck University, which is also part of the University of London, shared Su Wei-Tren's examiner names and viva date after an FOIA inquiry. There were no questions about legitimate interest. Anyone could access that information as long as they applied for it. Oxford University also came forward to expose Philippines President-elect Ferdinand Marcos Jr.'s academic dishonesty. Their actions disprove the ICO's explanations regarding Tsai's thesis. There are no personal harm concerns when it comes to publishing graduation information, contrary to what the ICO says. The decision the tribunal court handed Michael Richardson has no legs to stand on. The University of London and ICO have been spinning their wheels, all to buy Tsai Ing-wen time to bury her thesis controversy. But is time running out? Is the UK government getting ready to come clean? On June 2, 2022, Hollywood superstar Johnny Depp won his defamation lawsuit against ex-wife Amber Heard in the US. Their trial was live-streamed online for 3 weeks, and people tuned into it like it was primetime TV. Amber Heard ultimately lost her case because she couldn't get her story straight and her testimonies didn't add up. In the end, she was ordered to pay Johnny Depp $10 million in damages. The interesting thing is, this defamation suit has similarities to Thesis-Gate. In 2018, Johnny Depp sued UK publication The Sun for calling him a wife-beater. However, he lost the suit in UK courts after Amber Heard testified. The court said there was evidence to show Depp was violent toward Heard on 12 out of 14 occasions. However, in the US trial, all of the evidence used in the UK were shown to be Amber Heard's fabrications. That includes pictures of Heard with a bruised face The Sun published. Now that Depp has won his case in the US, Amber Heard could face perjury charges in the UK. Similar circumstances are taking place in the case between Richardson and the ICO. When it comes to Tsai's examiners and viva date, the UK courts took the ICO at its word and handed Richardson an initial loss. We see indicated in this initial decision published on September 13, 2021, that the ICO provided evidence to the tribunal. Let's look at points 34 to 36 of the ruling. Point 34 says, "We have read and taken account of an open and small closed bundle of documents." Point 35 says, "It is necessary that the documents in the closed bundle are not revealed to Mr. Richardson because to do otherwise would defeat the purpose of the proceedings. The tribunal accepts that in accordance with the guidance given by the Court of Appeal in Browning, we are required to disclose as much as possible about the closed bundle when writing our decision." Browning refers to a Freedom of Information Act case that took place in the UK court. It involved a reporter who was looking into weapons trading in Iran. The ICO ultimately refused to publish information in that case for lack of legitimate interest. However, the most interesting information comes in point 36, which is, in accordance with the guidance in Browning, the tribunal records that the closed bundle is limited to a document containing the requested information, the names of the examiners, and the date the examiners signed approval of the thesis. Tsai's cyber army loves to argue that since the UK tribunal says it has seen the information Richardson requested, then that should be enough to prove Tsai's education's legitimacy. That's what led to Richardson's loss in court. The question is, how were Tsai's examiners and viva date presented in this closed bundle of documents? Don't forget, on January 11, 2022, 4 months after the tribunal's decision, University of London Data Protection and Information Compliance Manager Susie Merriweather said on whatdotheyknow.com that the University of London does not have any records on Tsai's viva. That includes the date and examiner names. On November 26, 2021, LSE also denied holding Tsai Ing-wen's viva records. If both LSE and the University of London deny having Tsai Ing-wen's viva records, then who provided the information in the closed document bundle sent to the court? Is it the defunct transcript office? The written decision did not say where the bundle came from. The ICO didn't bother clarifying anything either. Furthermore, why did the court choose to refer to Tsai's viva record as a closed bundle of documents? The answer is simple. It's because the closed bundle of documents is not legally binding, nor are they school-sanctioned records. The information is derived from Tsai's mysterious 278-page student record pulled from the LSE archives. The examiners identified in those records are Michael Elliott and Leonard Lee, two people who we've proven at length could not be Tsai's examiners. We've already explained that those two people could not be Tsai's examiners. Michael Elliott was an LSE professor, while Leonard Lee's field had nothing to do with Tsai's subject matter. How could the two act as proper examiners for Tsai's viva? After proving Elliott and Lee couldn't have been Tsai's examiners, a third examiner, Richard Dale, was brought up as a possibility as well. In past episodes, we already deduced that all of this fake information vouching for Tsai's made-up past experiences constitute perjury. The wrongdoers in London fabricated this bundle of documents to fool the tribunal. The ICO is like the Sun, while Amber Heard is like the University of London. Both created falsehoods to prop up a lie. Will we overturn the tribunal's decision like Johnny Depp did with his case in the US? We shall see. Before the hearing in the UK, however, Dr. Peng's case against Tsai Ing-wen, which Judge Chang Wing-hui is presiding over, had a hearing on June 10, 2022. We've talked about Judge Zhang's unreasonable and illogical actions throughout this case. That includes her insistence on hearing the case even though she's not fit to do so. Judge Zhang gave a decision on the case at the district level before. The High Court overturned Zhang's ruling and sent the case back to the district level to be retried. Zhang was allowed to preside over the case again, which Dr. Peng took issue with. He demanded that Zhang recuse herself, but she refused to do so. Zhang's insistence on hearing this case hints at political manipulation behind the scenes. In her subpoena for the June 10th hearing, Judge Tsang insisted that both sides state their arguments for debate in writing beforehand. Her purpose for doing so was so that she could end trial proceedings after one hearing. Even though there is mountains of new evidence that suggests Tsai Ing-wen's thesis doesn't exist, Tsang is not bothering with an investigation. She fully intends on handing Tsai a victory, thereby creating a legal precedent for the existence of Tsai's thesis. Judge Tsang had a court clerk call lawyer Li Zhenhua, requesting that he provide his evidence to the court. At that point, we thought Zhang was going to take this case seriously for a moment. However, if the court was seriously going to investigate our points of suspicion, that would require acquiring documents from schools in the UK, which would take a substantial amount of time. There is no way one hearing would be enough time for Tsang to come to a sound and proper decision. Judge Tsang asked Dr. Pang's side to provide original documents as evidence, but she allowed Tsai's lawyer Lian Yuanlong to get away with providing courts a picture of Tsai's thesis as evidence. It's clear that Tsang is biased here. Li told the courts that the defense should be the one that's on the hook for providing original evidence, to which the court told him that they would remind the defense to also provide originals. This phone call between Li and the clerk would prove to be pivotal in the June 10th hearing. On one hand, investigators were worried that Tsang would rush to end the case after one hearing. At the same time, there was hope that the court would carry out an examination of evidence. Thesis-Gate lawyers were torn. After a week of deliberation, they made the following requests on the day of the trial. First, the lawyers would allow Judge Tsang to hear the case on the condition that she examine evidence thoroughly. If she looks into the plaintiff's points of suspicion, then they would not contest Judge Tsang presiding over the case. Second, in order to prevent Judge Tsang from carrying out Tsai Ing-wen's nefarious plans, the plaintiff did not want to go into any substantive proceedings without a few guarantees first. That's because if the case moved into substantive proceedings, then the plaintiff could no longer request a recusal. The plaintiff needed Tsang's word during the preliminary that she would investigate evidence and that she would not decide the case after one hearing. Third, if Tsang did not examine evidence in earnest, nor if she couldn't promise that she wouldn't end the case after one hearing, then Thesis-Gate lawyers would apply to have her recused. On the day of the hearing, Judge Tsang issued the following conditions to Dr. Pang, who streamed into the court from the US. He could not record any court proceedings without prior permission, and if he disconnected from the court within the first 3 minutes of the hearing, it would be seen as a no-show on the court's end. Afterwards, the hearing began. Judge Tsang asked if the plaintiff wanted to add any terms to the central issue of the case. Li Zhenhua said that Dr. Pang did have things he wanted to supplement. Judge Tsang, clearly wanting to move into formal proceedings, asked Dr. Pang what he wanted to add. If Dr. Pang did state his supplements right then and there, then the case would move onto formal proceedings, after which recusal requests could not be made. Dr. Pang greeted the court and pointed out that it had been 2.5 years since the case had been filed. He said during that time the case had come back to its starting point. Dr. Pang asked what the nature of the day's hearing was. Judge Tsang said that it was a debate hearing. She said that both sides will make their statements and that the judge was not to be questioned. She then asked what Dr. Peng's supplement was. Dr. Peng then pointed out that the case had not even had a pretrial nor an investigation inquiry and was now directly in the debate phase. Judge Tsang said that the hearing was a debate. Dr. Peng said that in the interest of justice, it was necessary for his side to develop trust and rapport with the judge and court, otherwise the hearing would be pointless. It would be a failure of Taiwan's judicial system. So Dr. Peng asked the court why there was no pretrial and why there was no inquiry. He asked what grounds could the case go directly to debate. Judge Tsang said she asked for supplementation, then she asked Peng's lawyers if they had a legal basis for not engaging in debate that day. Li Zhenghua said that he was happy the court wanted to move into formal procedure, but that he was afraid it would not be done on fair grounds. Li pointed out that 2.5 years ago, the case was returned to the district court because it did not go through proper procedure. The high courts found the process flawed. For some reason, the district court allowed Tsang to preside over the case again. Li said his side did not trust her to carry out proper trial procedure in line with the law. He said that the judge drawing mechanism was put in place to ensure fair and proper trials so that people could trust the system. Li said he found Judge Tsang untrustworthy because she refused to investigate evidence or recuse herself. Judge Tsang asked if the plaintiff was seeking a recusal. Li said that for his team to decide whether or not they wanted to recuse Judge Tsang, it all depended on whether she would be willing to assess the case fairly. Li said that if Tsang insisted on rushing procedures to finish debates in a single session, then there was no way he would let Tsang preside over the case. Li pointed out that the evidence in the case is complex and would require time to properly look over. Li said Tsang couldn't have seen the evidence because she had a clerk call and ask for original evidence. He asked if the defense provided their evidence and whether or not that evidence had been tested. Li said there was no way a proper trial could proceed the way things stood. Insistent on moving the trial into debates, Tsang asked again to confirm its primary issue in the case. Li responded by asking Tsang head-on if it was her intention to end debates after this one hearing. He said if that was her intention, then he'd apply for recusal. Li asked Tsang if she had any plan to carry out a fair and just trial. Judge Tsang said that during the case's first hearing on April 16th last year, the plaintiff made many motions to challenge her overseeing the case. She said that those motions have come and passed, and that's why the hearing could continue that day. Everything had been according to procedure. Judge Tsang said whether or not debates would end that day would depend on how the case moved forward. She said that the hearing was not the first time that the plaintiff and defense met. Tsang said that debates were scheduled for the day according to legal procedure. She said that if the plaintiff took issue with prior procedures, then they would have to obtain the defense's opinion. Lee said he understood, but he also said that evidence investigation and compilation were also customary before a hearing. Tsang said that evidence examination would also take place that day, and she said she was moving forward with the hearing. Lee agreed to that, but asked again if Tsang was going to end debate procedures that day. Tsang said it was impossible for her to know how the hearing would play out. She pointed out that neither side had given any statements yet. Lee insisted on an answer. He said if she promised not to end debates that day, then he'd agree to let her preside. Tsang said again there were no statements. Lee asked Tsang if her intention was to end debates after one hearing. Tsang then asked both sides' lawyer to cooperate with procedures, otherwise things could not move forward. Judge Tsang could not promise that she would not end debates after one hearing. Things unfolded in the manner we expected. Judge Tsang had no intention of looking into the defense's forged evidence. She wanted to finish debates as soon as possible. If Lee agreed to move forward with the case, then the plaintiff would lose the ability to apply for a recusal. Why was Tsang so intent on hearing this case? Lee pointed out that the plaintiff lawyers each had over 30 years of experience. The other attorney, Jim Chang, had even been a judge before. Lee said they were both very clear on what proper procedure was. Lee said, judging from the documents the judge requested and the time that was set aside for the case, it was clear what was going on. Tsang wanted to end debates as quickly as possible. It was clear even to Lee's assistant. He said if Judge Tsang went through with it, she'd be giving a verdict without a trial. It's simple. Did Lian produce a copy of Tsai's thesis? If he didn't, then there's no logical or reasonable reason for debates to end that day. In one case, photocopied documents submitted to evidence did not have signatures. However, in another case, the same documents suddenly had signatures when submitted to evidence. Were the courts even aware of such flagrant malfeasance? Tsang might have thought that she had grounds to end the case, considering the defense had many documents and statements from the University of London, but the case's ultimate verdict can't hinge on such flimsy materials, now when Tsai's own employment records expose glaring holes in her own story. Judge Tsang continued saying that without knowing what new evidence there was, it was impossible for her to know how long debate would take. Tsang wanted nothing more than to move into formal procedures before she could get switched out. Lee said that if he moved forward with the procedure, he'd lose his ability to recuse the judge. That's why he wanted to know if Tsang would commit to examining evidence and not ending debate after a single hearing. Tsang insisted on not giving a direct answer. She told Lee to respect court procedure. Jim Chang then stepped in and accused Tsang of wanting to decide the case before clarifying its circumstances. Jim said that it was improper for Judge Tsang to move so swiftly without at least determining the details of the case. Jim said if Judge Tsang insisted upon her current course of action, then he'd apply for a recusal because she had already made up her mind before the trial even started. It feels like Taiwan's district court uses the term debate loosely. The courts use debate procedure to encompass anything and everything from preliminary procedures to evidence examinations. That's why Li Zhenghua and Jim Chang took such issue with the judge. It's impossible to know what will happen during these debates. If the court's intention was to close the case without a proper trial, then it would have been impossible for the plaintiff to establish trust with the judge. Judge Tsang continued to push forward, asking the defense if it wanted to supplement anything to its claims. Both Li Zhenhua and Jim Chang protested Judge Tsang's sudden advancement of the trial. They said that they were not ready to move on just yet. If Tsang insisted on moving forward, then the plaintiff would be forced to recuse Judge Tsang. Judge Tsang continued to insist on hearing the case. The only reason for such persistence was political pressure. Judge Tsang asked if the plaintiff wanted to recuse. Dr. Peng asked Zhang how she intended to carry out debate in the absence of proper pretrial procedures and a lack of hearings over the past 2.5 years. Judge Tsang asked Dr. Peng to answer her question. She said that since they were in a civil trial, the debate procedure would include evidence examination. Judge Tsang asked what Dr. Peng's opinion about recusal was. Dr. Peng said he couldn't respond to that question. He said Judge Tsang had no intention of handling this case in a serious or just manner. Peng pointed out that his lawyers had not been given sufficient time to prepare for the current hearing. He asked if the courts showed a sufficiently proper attitude when handling this case. Proving a thesis' existence shouldn't be done through debate, rather it must be done through proper evidence. Judge Tsang said that she sent out hearing notices a month prior and told both sides to make preparations. She said she did not send out notice as last minute as the plaintiff had described. Judge Tsang reiterated that the case at hand was a civil procedure and not criminal. She said that evidence examination would also be done during debate. Judge Tsang said she did not insist on hearing the case, nor did she have any intention of handling it incorrectly. She said she would recuse herself if she were given proper reason. She said it was up to the plaintiff if they wanted to move forward. She said that the courts were not a place for a TV show, but a place of law. Judge Tsang said that she was charged with facilitating the procedure and told the plaintiff to stop stalling. Lee Zhenghua then said there was a lot of evidence to go over and there was no way the debate could end in one hearing. He asked the judge if she agreed. Judge Tsang insisted on going ahead with the trial. Jim Chang then said that his only course of action was to file for a recusal on Dr. Peng's behalf. Going past that point would mean that the plaintiff would no longer have a right to recuse the judge. Jim Chang provided 2 legal bases for his recusal request. Attached were 11 pieces of evidence supporting his claim. That's when Judge Tsang decided to determine the grounds of the recusal request herself. She asked why it took the plaintiff so long to file a recusal request, seeing how the case had been in circulation for over a year now. Jim Chang said there wasn't a time constraint on filing recusals, only proper grounds were needed. He said it was impossible for the plaintiff to know that Judge Tsang wouldn't rush procedure. Judge Tsang asked if the plaintiff thought she failed in her duty. Lee Zhenghua said that one of the reasons for requesting a recusal is based on the fact that the judge could not process the case in a fair manner. Dr. Peng is also seeking legal action against Judge Tsang, which constitutes a conflict of interest. Judge Tsang then asked Lian Yuanlong for his opinion. Lian said that the case started holding trials in April of last year. Evidence had already been submitted and reviewed. He said that the plaintiff should bear responsibility for any disadvantageous developments in the case. Judge Tsang then said she determined the recusal to be a stalling strategy and rejected the request. She said there was no proper basis for the recusal request and said that the plaintiff must bear responsibility for its position in the case. Jim Chang then said that the plaintiff would take responsibility, but the decision to recuse Judge Tsang cannot come from herself. Instead, it must be decided on by a panel of judges. He asked Judge Tsang how she could come to a conclusion about her own recusal. Judge Tsang said she offered a legal basis for her decision. Jim Chang then insisted that Judge Tsang needed to have a panel of judges review the recusal request. Judge Tsang said she would send the case to the necessary administrative body in the court. Judge Tsang said she had to decide whether it was necessary to suspend the trial procedure at hand. She said she didn't find it necessary and wanted to move forward. If the plaintiff did not agree to debate, then the defense could offer their views uncontested. Lee Zhenghua said that the plaintiff would withdraw from court, citing a lack of faith in the judge. Judge Tsang said that she would allow uncontested debate if the plaintiff left. Jim Chang then said winning wasn't his goal, but he said he now knew where Taiwan's justice system stood after seeing it handle this case. Judge Tsang then asked Dr. Peng if he wanted to offer supplement or enter debate proceedings if his lawyers left the court. Judge Tsang was hoping Dr. Peng would let something slip and allow the trial to move forward. Dr. Peng only commended Judge Tsang for being so shameless to the point of bravery. After Li Zhenghua and Jim Chang left the courts, court observers also emptied the chamber as well. Judge Tsang insisted on continuing with the hearing and allowed the defense to debate uncontested. However, unexpectedly, Lien Yuanlong declined the opportunity, which hindered Judge Tsang from issuing a verdict. Li Zhenghua believes that it would have been horrible optics if Judge Tsang issued a default judgment without a thesis or original documentation for Tsai. He thought under those circumstances, the High Court would overturn Tsang's decision a second time. The story above is how the hearing of Dr. Peng's case against Tsai Ing-wen most recently played out. Judge Tsang wanted nothing more than to issue a judgment. She was insistent to the point that one could not be blamed for thinking something foul was afoot. Did the court clerk really request original documentation from the defense? Thanks to Li Zhenghua's quick thinking, he blocked Judge Tsang from making a verdict when he requested that Tsai's original evidence be submitted to the court. The case will no doubt once again go into limbo. Now all we can do is wait for the hearing in the UK. Thank you to all of our supporters who help us write history. We will see these cases to the end.